Hello, my name is attorney Megan Thomas and I'm a property lawyer. That means I get to help small businesses, individuals, and companies protect their intellectual property, their personal property, and their real property. So this is my very first YouTube video, and it's the first of my YouTube series called On the House. On the House is where I put together useful information and content for individuals in the areas of real, intellectual, and personal property law. So today we're going to be talking about 10 things you need to know about trademarking. The first thing I think you need to know is when to use the TM symbol and when to use the R registration symbol. R registration. You use the TM symbol prior to registering your trademark with the United States Patent and Trademark Office, or USPTO, or any other international trademarking body. That's when you use the TM symbol. You use the R circle, or the registration symbol, after registration. So the reason you use the TM symbol prior to registration is because that's actually evidence that you have held out to the public that you intend for that mark or that logo to be your trademark. This is important because the US trademark system is based on the doctrine of first use. We'll get into that a little bit more later, but just know you can use the TM symbol right now even if you haven't registered your trademark. So the second thing I think you need to know about trademarking is when to trademark. How soon can you register for your trademark? So the answer there is it depends. And it depends on, are you currently using your product in interstate commerce? Now, what's interstate commerce? Interstate commerce is when you are literally selling your product to a customer or an end user in another state. So that means if you're sitting in Alabama, are you selling a product to someone in Georgia? That's considered interstate commerce. If you're using your product in interstate commerce, go ahead and register it right now. If you register and you have not used your product in interstate commerce, then you're going to have to register under intent to use. What that means is that you're going to have to later supplement your application to certify to the USPTO that you are actually using your product in interstate commerce, and you must do that within 6 months. Okay, so the third thing I think you need to know about trademarking is what actually is being protected by your trademark registration. So your trademark registration actually protects your logo, your brand name, or whatever it is that you've certified is your mark that you're using in interstate commerce. Now, the good or the product itself may be afforded protection under some other area of intellectual property law, such as patent protection or copyright protection. However, the trademark registration only protects the brand name, the mark, the logo, not the actual good or service itself. So just know that you may have to then apply for some other form of protection to actually protect your product more completely. Okay, so the fourth really important thing that I think you need to know about trademarking is that your actual product packaging or the container that your product sits in may also be afforded protection, and as a matter of fact, it generally is. So trademarks protect actually the identifying mark that symbolizes your good or your service. However, the actual packaging that the product sits in or the container that the product sits in may also be afforded protection under trademark law under the principle of trade dress protection. Now, trade dress, again, it protects the packaging in the container. However, you generally don't need to file any additional registration to be afforded trade dress protection. So just know that even if someone is actually not using your actual trademark, not the mark or the logo itself, but they're still trying to mimic your product or make their product look like yours because they're using a product packaging that is so similar to yours that is creating confusion in the market, you may still be afforded protection under the principle or doctrine of trade dress protection. All right, so the fifth thing I think you need to know about trademarking is whether or not your slogan is automatically afforded trademark protection. So generally speaking, if you want your slogan to have trademark protection, you're going to have to register it. So one of the key considerations you're going to have to think about when determining whether or not you're going to register your slogan is whether or not you want to register it with your brand logo. So if you register your slogan with your brand logo, then that slogan may only be subject to protection in use with your brand logo. If you register your slogan separate from your brand logo, then it will be entitled to protection if you use it outside of that brand logo. All right, so the sixth thing I think you need to know about trademarking is when your trademark expires. And the answer there is that it may never expire. Your trademark rights could go on in perpetuity if you continue to use your mark. So the US common law system is a use it or lose it system. If you stop using your mark in interstate commerce, then you could lose federal trademark protection. And this is so important that the USPTO also requires trademark owners to certify their continued use by filling out supplementary forms. Now, up until this year, the USPTO was not super aggressive about policing the trademark system and ensuring that trademark owners certified continued usage. However, the Trademark Modernization Act, which recently passed, requires the USPTO to go into their system and purge out registrations that don't have certifications of continued usage. So just know, if you don't certify continued usage, you could later lose your trademark rights. All right, so I've thrown a lot of information at you, and now I'm gonna toss you an easy one. So the 7th thing I think you need to know about trademarking is just how far your trademark rights go. So the answer is super easy and straightforward. If you register your trademark here in the United States, in the United States alone, then your trademark rights are generally going to be limited to here in the United States. Full stop. So that means, generally speaking, there are some exceptions, and I'll talk about that in another video. But if you want trademarking protection internationally, you're going to have to register your trademark internationally. All right, so the 8th thing I think you need to know about trademarks is how broad your US protection rights are. So yes, we know if you register in the US that you'll be protected here in the US, but how far does your protection go? So in the US, there are 45 separate classes for goods and services within the US trademark system. So what that means is, if you want to create a soda brand and you create a logo for that brand, and then you want to also sell t-shirts bearing that same logo, but you want protection for both, then you're going to have to register in 2 separate classes. So beverages and apparel are in separate classes within the USPTO's registration system. Therefore, you're going to have to pay 2 different application fees. All right, so the 9th thing that I think you should know about trademarking is whether or not you should put the trademark in a company's name or to keep it in your name. Now, just consider this. There is nothing wrong with putting a trademark in a business's name. However, if there are other owners in that business, just know that if the company later splits up down the line, you may have to negotiate with the other owners about your trademark rights. If that's the intent, if the intent is for the company and all owners of the company to own the trademark and own the trademark rights, great. But if that's not the intent, just know that that may be a risky business decision for you. All right, so we are down to the final stretch, and the last thing I think you should know about trademarking is that the US trademark system is based on the first use doctrine. Remember, we talked about first use a little bit earlier. So what is first use? First use literally means that federal trademark protection is afforded to the first to use a trademark in interstate commerce. The first to use. That is not the same as registration. So if you are using a trademark in your little mom and pop in Idaho and you are shipping or selling products to Minnesota, then know that even if you don't register your trademark, then you are still afforded trademark protection here in the US. Now, what else does that mean? That means that if you have a federal trademark registration, and then this mom and pop in Idaho finds out that your federal trademark registration infringes upon the trademark that they've been using for the last 20 years, and you've only been using your trademark for 5 years, that your trademark could later be invalidated, unregistered, and you could receive a cease and desist letter from mom and pop in Idaho. Yes. So not every company that has a trademark that is worthy or suitable for protection here in the United States has their trademark registered. They just don't. But they are still afforded protection under the US trademark system. We have a common law system, and under our common law system, our system affords protection to the first to use a trademark. So those were just the 10 basic things that I think that businesses or individuals who are currently selling products or services, or that are considering to sell products or services here in the US, need to know about trademarking. Now, those items apply whether or not you are considering getting a registration or have a registration. It's important to understand your rights. Now, these were just the surface level principles. I'll be taking a deeper dive into some of these areas in the weeks to come. Now, if you're looking for an overview on the trademarking process in general, feel free to download my free trademark process guide in the description box, and I hope to see you next time. Thanks so much. Now, what that means is that if you want, not right now, give me a second. Yes. Yes. Yes.
Tell them to watch that. You gave Wayne her popcorn, but you didn't give
I left it on the counter, silly.
Oh, so you were.
Yes.
So I was right?
Mm-hmm.
You wanted us to get our own popcorn?
Yes, it's on the counter.
Oh, okay.
Okay, close my door. I love you.
Sorry again.
No, you don't have to apologize.
Bye.
Love you.